Hello everyone, this is Bill Griffin. Welcome to Different Take Podcast. If you like this content, please subscribe, like, share, comment, and I appreciate you watching. Today I want to follow up on an episode that I did regarding the recent leak of an order written by Samuel Alito, Supreme Court Justice, that is maybe in a majority opinion, we don't know, overturning Roe versus Wade, and that which would change how abortion is dealt with and abortion laws are written in the United States. There is a 67-page opinion with about 30 pages of appendixes listing different cases he draws the opinion from and so forth and so on. I want to go through that because I think it's pretty logical and it is very readable. But before I do that, people are politicians. Their hair's on fire. They're going really crazy over this thing. It's a diversion. This is if these politicians, senators, were that serious about codifying Roe versus Wade, they would have done this a long time ago. And in fact, even if they had done so, if Roe v. Wade is overturned, it won't matter. That the Supreme Court rules supreme in this. But the left-wing media and Democrat politicians are saying this is the worst thing ever. And as I said in the other episode, who knows if things will change very much, and there might even be even more abortion rights. Similar in it, you might see laws that are similar to Europe, which they are more restrictive than, say, the state of New York, which is pretty, I think they allow abortions up to 26 weeks or so. Actually, New York allows abortions, the standard is viability, which could be, that's up to the doctor, I suppose. But they have the highest abortions per capita in the United States. District of Columbia is higher, but as far as the state goes, New York is the highest. They have the most abortions. Before I go through this, I want to show you a article of Ruth Bader Ginsburg, Chicago School of Law, University of Chicago School of Law, and she says, "My criticism of Roe is that it seemed to have stopped the momentum on the side of change." Ginsburg said she would have preferred that abortion rights be secured more gradually in a process that included state legislatures and the courts, she added. Ginsburg also was troubled that the focus on Roe was on our right to privacy rather than women's rights. "Roe isn't really about the woman's choice, is it?" Ginsburg said. "It's about the doctor's freedom to practice. It wasn't woman-centered, it was physician-centered." So she has a criticism of Roe versus Wade, and she would not, I don't think, have ever voted to overturn this, but she would have used the doctrine of precedent to support that. But she didn't agree with the logic of the ruling. Well, along comes Samuel Alito, and he writes an opinion that everybody's so surprised about, but there really shouldn't have been anything to be surprised about. So I want to go through this order, or opinion, I should say, and it is, as I said, very readable. So this is from page 5. "We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty." So Roe versus Wade was handed down, I believe, in 1973, and Casey was something like 30 years ago, which upheld Roe to to some degree. This is from page 7. It found that most abortions after 15 weeks employ dilation and evacuation procedures which involve the use of surgical instruments to crush and tear the unborn child, and concluded that the intentional commitment of such acts for non-therapeutic or elective reasons is a barbaric practice, dangerous for the maternal patient, and demeaning to the medical profession. So what he's referring to there is the idea that there are protections from for the unborn child. Page 9. Roe, however, was remarkably loose in his treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. And that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions: the First, Fourth, Fifth, Ninth, and 14th Amendments. The court's discussion left open at least 3 ways in which some combination of these provisions could protect the abortion right. One possibility was the right that founded in the 9th Amendment's reservation of rights to the people. Another was that the right was rooted in the First, Fourth, or Fifth Amendment, or in some combination of those provisions, and that this right had been incorporated into the Due Process Clause of the 14th Amendment. So, Alito's reasoning here, I think, is that instead of pointing to one specific place in the Constitution, they're picking and choosing where this to get this right, and it's a right of privacy, as Ginsburg said. Page 15. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. 0. None. No state constitutional provision had recognized such a right. Until a few years before Roe was handed down, no federal or state court had recognized such a right, nor had any scholarly treatise of which we are aware. And although law review articles are not reticent about advocating two rights, the earliest article proposing a constitutional right to abortion that has come to our attention was published only a few weeks before Roe. Not only was there no support for such a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and the remaining states would soon follow. Page 31. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interest of a woman who wants an abortion and the interest of what they termed potential life. But the people of various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. So in that passage, abortion rights advocates that are so upset about Roe v. Wade being overturned fail, or maybe they're being misled or haven't done their own research to understand that this actually could expand abortion rights, and some people believe up until the time the birth occurs. Page 47. This arbitrary line has not found much support among philosophers and ethicists who have attempted to justify a right to abortion. Some have argued that a fetus should not be entitled to legal protection until it acquires the characteristics that they regard as defining what it means to be a person. Among the characteristics that have been offered as essential attributes of personhood are sentience, self-awareness, the ability to reason, or some combination thereof. By this logic, it would be an open question whether even born individuals, including young children or those afflicted with certain developmental or medical conditions, merit protection as persons. But even if one takes the view that personhood begins when a certain attribute or combination of attributes is required, it is very hard to see why viability should mark the point where personhood begins. Page 49. Is a fetus viable with a 10% chance of survival? 25%? 50%? Can such a judgment be made by a state? And can a state specify a gestational age limit that applies in all cases? Or must these difficult questions be left entirely to the individual attending physician on the particular facts of the case before him? The viability line, which Casey termed Roe's central rule, makes no sense, and it is telling that other countries almost uniformly eschew such a line. The court thus asserted raw judicial power to impose, as a matter of constitutional law, a uniform viability rule that allowed the states less freedom to regulate abortion than the majority of Western democracies enjoy. Page 49 is page 50. All in all, Roe's reasoning was exceedingly weak, and academic commentators, including those who agreed with the decision as a matter of policy, were unsparing in their criticism. John Hart Ely famously wrote that Roe was not constitutional law and gave almost no sense of an obligation to try to be. Archibald Cox, who served as Solicitor General under President Kennedy, commented that Roe reads like a set of hospital rules and regulations that neither historian, layman, nor lawyer will be persuaded are part of the Constitution. Lawrence Tribe wrote that even if there is a need to divide pregnancy into several segments with lines that clearly identify the limits of governmental power, interesting balance of the form the court pursues fails to justify any of the lines actually drawn. Page 51. Problems begin with the very concept. Casey's undue burden test has scored poorly on the workability scale. In the next paragraph. Problems begin with the very concept of an undue burden. As Justice Scalia noted in his Casey dissent, determining whether a burden is due or undue is inherently standardless. Whether a burden is deemed undue depends heavily on which factors the judge considers and how much weight he accords them. Page 60. Our decision returns the issue of abortion to those legislative bodies and allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Women are not without electoral or political power. Pardon me, that was page 61. Page 66. A law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of validity. It must be sustained if there's a rational basis on which the legislature could have thought that it would serve legitimate state interests. These legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. Page 67. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. The judgment of the Fifth Circuit is reversed and the case is remanded for further proceedings consistent with this opinion. That is some passages from Samuel Alito's opinion that maybe the majority opinion, we don't know, overturning Roe versus Wade. Pretty easy to read, pretty easy to understand. I know I'm being redundant, but the politicians, Democrats, and left-wing media, they are beside themselves with anger and they're inciting fear in many women that they won't have the right to an abortion, because many women believe that they should have the right. Many people do. However, they could actually expand the rights in their state over and above what Roe versus Wade would allow. So I think that's something that is missing, and people, unfortunately, just are not, maybe they're not read up on it. I don't know. But I hope this was helpful, and I appreciate your watching. If you like this content, please subscribe, like, share, and comment. I really appreciate you watching. Check out the platforms we're on. Thank you.